Hey, Dennis Mattern here with C1 Insider, your resource from CreativeOne for all things tax, legislative, or regulatory that could affect you, your practice, and your clients. We're here today to talk about the DOL Fiduciary Rule and some breaking news on it. Andrew, what's going on?
Well, there's been an injunction put on the new fiduciary rule, so it will not go in place in September as originally planned. But let's take a couple steps back. As we all know, there was the new version of the fiduciary rule. There's a lot of different versions. There's 1.0, 2.0, but what we're talking about is the one released in April. Okay. This is the one that was said to be going into place in September of this year. There were some lawsuits, two to be specific, regarding this case challenging the validity of this regulation. Mm-hmm. The first one is the Federation of Americans for Consumer Choice case. And in that case, they asked for an injunction, which means that the rule doesn't go into place. The rule is stayed while the litigation plays out. And in that case, there's a lot of different standards you have to meet, but one of them is the likelihood of success on the merits. And so they had an oral argument earlier this week. They hashed it out, and then yesterday the judge issued the injunction, a nationwide stay of the rule, so it will not go into effect in September while this litigation plays out. This is not an ultimate victory. This is not the rule has been vacated, but it is an injunction. The rule is stayed while the litigation plays out. There's a second case too, and I'll get to that. The second case, we're expecting the same result, and that's probably going to come out today or next week. Mm-hmm. And so we're going to have two cases with stays on it where the rule is said to not go into effect. We're going to see how this litigation plays out. Once that lawsuit is done, then the judge can decide whether it can go, if it's valid or not, whether it can go into effect or whether it remains off the books.
So how long, just not putting you on the spot, but how long of a time frame are we literally looking at here? Is this years,
there's an opportunity here for everyone to get a good law school course in federal courts and appeals. But essentially, we don't really know. But what we expect is that the Department of Labor will appeal this injunction. So that'll be the first appeal to the circuit court. And they'll take it up to the circuit court and say this injunction was decided wrongly. I don't know how long that will take. That's likely is going to take a while because there's a big briefing schedule that have to go through. So it's not going to be by September.
Gotcha.
If it does get overturned, which I don't anticipate that happening, it would go back down to the district court to have the case go through its full trial, full briefing. We haven't even started this trial yet. We're just on the injunction. Sure. And there's two of them, so there's a couple different ways this could play out. But ultimately, in this injunction, the judge signaled kind of where he was going with this. And he said that there is a likelihood of success that the plaintiffs or industry, the FACC, and in the other case, it's IRI, ACLI, NAFA, and NAFA, that there's a likelihood of success on the merits. And so all that to be said, the September date likely is not going to happen. I think we'll see some communication from carriers to say we're holding off on anything formal for September while we wait to see how litigation plays out. Then we're kind of just waiting. We're waiting to see how the district courts rule. We can prognosticate, pretty closely to how we think that's going to end up. We think that'll be in industry's favor. Where the real battle will happen is at the appellate court level. And at the appellate court level, the circuit court, they'll have to decide this issue. The real problem with that is that could come a year from now, that could come 2 years from now. So this is going to be pushed out quite significantly. There could be an expedited hearing schedule where this happens more quickly. It's unlikely for that to happen, but that's why we need to keep an eye on it going forward. But ultimately, what we do know is there's an injunction. The September date is likely not going to happen. We will likely see some communication from carriers in the next week or so saying, we're going to pay attention to what's going on, but we're not going to have any new requirements for September.
So let's talk about requirements that are in place then. So no new requirements in September, but that doesn't mean that I still have, I'm still doing an 8424.
You're still doing an 8424 just like you are today. The previous rule is still on the books. The previous 8424 requirements are still on the books. So continue to do that. Continue to paper up your file. Continue to justify your recommendation. Put that into your file. Everything that you're doing now, continue to do. There's just not that extra work that has to happen from the new rule that was supposed to go into place in September.
Perfect. Andrew, thank you so much. And for everybody out there, we will make sure that you are apprised of what's going on. Again, this is C1 Insider, your resource from CreativeOne for staying up to date with all regulatory, legislative, and other challenges that could affect you, your practice, and your clients.